Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and I will be your host for today's webinar. And today we will discuss the regulatory and legal issues of the Federal Telephone Consumer Protection Act, also known as TCPA, and also the Florida's TCPA, which was enacted and went into effect July of this year. I'd like to thank all of you for attending and participating in today's webinar. I hope to make it as interesting as possible for you. I also thank those who recently attended our firm's regulatory workshop in Costa Mesa, California. We got fantastic feedback and hope to see you at our future in-person events. And before we begin, I'd also like to give a quick plug for next Wednesday's webinar, which will be announced later today. And that will be our last webinar for 2021. It's going to essentially have the recap of all legal and regulatory issues in the debt relief space that took place in 2021. And what a busy year it was. Finally, today's subject matter is one that is quite dense. It is one that I will read off the slides significantly more than I typically do for all other webinars. It's a subject matter that could easily take half a day, even a full day to discuss. And I try to condense it in 30 to 45-minute presentation. Of course, if you have any questions, I'll have my contact information at the end of the presentation, and you can reach out to me with further questions. If you're new, a little bit about myself. I am an attorney based in New York. Our firm has offices in New York, Miami, and London. I am the managing partner of the firm, and I'm based out of New York and also spend a lot of time in Miami. During the year, I teach at Hofstra University School of Law. I've taught numerous courses, and particularly now have in my 5th year teaching course on the regulation of cryptocurrencies. In the debt relief space, I serve as a board member and a secretary for an industry trade association called Consumer Debt Relief Initiative, CDRI. And let's move on. So we have a lot to cover today. As you could see, the topics for discussion. We'll begin with the background of TCPA. We'll discuss what is defined, how do you define the automated telephone dialing system, or ATDS. So during this webinar, I will probably continue just using the acronyms like TCPA or ATDS, just so that we can move forward and shorten the time of a necessary long wording of these definition of these words. Anyway, TCPA regulations on text message communications with consumers. We'll discuss maintaining compliance with TCPA. We'll discuss when consumer cannot be called. We'll have a distinction between the differences of what the time differences between the federal and the Florida TCPA. We'll discuss the exemptions from the do not call registry, best practices, maintaining compliance. That's an excellent one, I think, for most of you. Florida's new TCPA laws, and also the following class action litigation in Florida that took place, that has arisen since July of this year. And I'll give you a number of cases that you should perhaps follow and be aware of. And obviously, the biggest one is comparison of federal and Florida TCPA statutes. That's very important, because on a daily basis we have questions of what's the difference between the two, and we'll discuss that today. Now let's talk about the background on federal TCPA laws. Right, first it was signed actually 30 years ago. I can't believe this. The law has been, TCPA has been around since 1991. It was signed by George H.W. Bush. And it restricts, the law itself restricts telemarketing and specifies several technical requirements for fax machines. Can you believe we talk about fax machines? I don't know if anyone actually has a fax machine anymore. Auto dialers and voice messaging systems requiring identification and contact information of the entity using the device to be contained in the message. The TCPA law also restricts telemarketing for the use of the automated telephone dialing system, ATDS. The TCPA also includes the National Do Not Call Registry. I remember the day when the Do Not Call Registry came out online. Um, and as you know, in my webinars, I always like to add a little bit of personal thought into this. And I remember how excited my parents were to stop receiving those phone calls from telemarketers, and they had me input their phone number with the hope that they will stop receiving those automated pre-recorded calls. Of course, 30 years later, those calls continue. And funny enough, they actually continue more than ever. So kind of an interesting question to ask whether TCPA has been effective or not. And obviously, that's not the purpose of this webinar. But 30 years later, I think we still would say that the problem is big, if not bigger than ever. And one thing that's also very interesting, extremely interesting, is that this TCPA, while federal, does not preempt state law. It does not preempt state law. And that's, for those of you who are attorneys on the call, that's a very interesting distinction. For most part, most federal laws will preempt state laws, and they'll state so. In this particular case, federal legislators actually allow the states to create on their own regulatory scheme. And that's why we have the mini TCPA law in Florida. Although we'll discuss why it's not technically a mini TCPA. You could say it's a bigger TCPA for the state of Florida. All right, so the TCPA defines ATDS as, and let's read this carefully, equipment which has the capacity to store or produce telephone numbers to be called. Store, produce telephone numbers to be called. That's very, very important, because you need to have the ability to store and produce telephone numbers to be called using a random or sequential number generator, and B, to dial such numbers. And we'll discuss later on in this presentation of how the part A of this definition was actually litigated. And we'll discuss a few cases. To qualify as ATDS, a device must have the capacity either to store a telephone number using a random, and random is actually kind of interesting here, because random becomes really the focus of most litigation here, and will be one of the key distinguishing elements from the Florida TCPA, because in Florida, you don't need the random to be the catalyst for Florida TCPA to apply. I know I'm jumping a little bit ahead, but I want to focus on the word random. So again, to qualify as an ATDS, a device must have the capacity to either store a telephone number using a random number generator or produce a telephone number using a random number generator. A calling platform must be capable of originating a call or sending a text without human intervention, in order to qualify as automated auto dialer under TCPA. Again, I'm focusing on a few keywords, and if those of you who have previously attended my in-person events, I focus on these keywords because it is extremely important to focus on some wording, and not just some wording, specific wording of these statutes and these definitions. Because in order for you to properly comply with this law or many other laws, you have to focus on the catalyst, what I call catalyst words that basically the nuclei or nucleuses of these statutes or these definitions. Okay, now the TCPA only prohibits the use of devices that generates numbers randomly, and again that was established by case law. We'll discuss later. And finally, no federal law currently prohibits businesses from using computers that store telephone numbers to automatically dial or text consumers, right? So that's a very big distinction. Let's talk about text messaging. Text messaging is a phenomenon that existed now for 2 decades. It's become quite significant. I think it's quite incredible that text messaging today's people don't call each other anymore. So text messaging, and particularly for marketing purposes, for lead generation purposes, for staying in touch with your consumers as prospective consumers, has become such an important, integral part of any business. I recently, purchased a car, and most of my interaction to inquire about, cars quote and inventory was all done through text messaging, not by phone. Which is quite nice because as you probably don't have the greatest experience of dealing with too many car salespeople, and so text messaging has always been quite big significant. So text messaging, you cannot text message consumers without their permission. This will violate TCPA. All communication between business and the consumer must come only after the consumer provides express written consent. If a consumer signs up for business alerts via text, they must also confirm the subscription via automatic confirmation message sent by the business containing TCPA mandated disclosures. Any text message requesting payment by credit card or release of additional identifying information before the actual message will be revealed will violate the TCPA guidelines, right? So you can't request someone to text you credit card information. You could be in violation of TCPA. Messages sent to consumers that require the receiving party to use the scrambler to understand them violate TCPA. Specifically, any unintelligible or incomprehensible audio also violates federal law. Once consumers opt in to receive messages, businesses must disclose the full scope of their SMS communication and also provide a way for consumers to opt out. As you're probably listening to this, you're scratching your head and asking yourself, how many text messages, spam text messages you received probably in the last week that did not follow these instructions or did not follow these requirements? Now, companies must maintain company-specific do not call list, right? So if you are a debt relief company, a credit counseling company, a credit repair company, you have to have your own do not call list. If somebody asks you to take themselves off a call list, you have to do that according to federal TCPA. The time frame when you can only make calls is between 8 a.m. and 9 p.m. local time. And this is something interesting, the abandoned call rule. It's quite often ignored for those who are using automated dialing systems. If you're abandoning calls means they're call very short in time or do not have any specific number of rings, you'll be in violation of TCPA. So there are 3 prongs here. You have to ensure that no more than 3% of all calls answered by live consumers are abandoned. You have to allow the telephone to ring for at least 15 seconds or 4 rings before disconnecting, and plays a message when a call is abandoned that provides a name and telephone number of a telemarketer and the purpose of the call, and an automated opt-out mechanism. So part C is also very, very critical, right? You just want to make sure that you're obviously not abandoning the call, and part C is one of the more difficult prongs to meet here. Now, all pre-recorded messages, whether delivered by automated dialing equipment or not, must identify the name of the entity responsible for initiating the call, along with the telephone number of the entity that used during the normal business hours task, not to be called again, okay? You must maintain a process used to access the National Do Not Call database, right? So if you're on compliance side, you want to make sure that you have a process, and I'll mention in a few minutes what that process could be in best practices. You should maintain a process to ensure that the financial institution, any third party engaged in making telemarketing calls on behalf of the financial institution, does not sell, rent, lease, purchase, or use the National Do Not Call database for any purpose except for compliance with the TCPA. You should maintain a process to ensure the telemarketer is making telemarketing calls or providing the called party with the name of the individual caller, the name of the financial institution on whose behalf the call is being made, and the telephone number. And that's not using the 900 number, for those of you who remember the 900 numbers 30 years ago now, or long distance number or address at which the financial institution may be located. Okay, this is a lot of information, and as I mentioned, this will be quite dense. All numbers on Do Not Call registry, including banks, insurance companies, credit unions, and savings associations, and other business entities, including third parties acting as agent on our behalf of financial institutions. And no seller entity telemarketing on behalf of the seller can initiate a telephone solicitation to a residential telephone number who has registered that phone number a Do Not Call registry. There is a safe harbor provision, and here it is. You should have, so obviously, if you make, as part of your routine practices, if you make good faith error. You have, if you show you have written procedures and you train your personnel and you have maintain telephone numbers that are excluded from contact, right? So somebody asked you to take them off the list. Use of the version of the National Do Not Call Registry obtained no more than 3 months prior to the date, and process that you have ensures that it does not sell, rent, lease, or purchase. Do not call database in any matter except in compliance with regulators. That could be your safe harbor. Okay. All right, and then let's go on to further exemptions. The exemptions, right? So previously that was the safe harbor. These are the exemptions. And the exemptions are very, very narrow. That organization that's making the call has an established business relationship with the consumer consisting of either 3 months of inquiries to prospective customers or 18 months of past transaction, right, with your former customers or current customers. You should have prior written consent of a consumer. If you have prior written consent, obviously it makes the entire process a moot point. Calls by non-profit organization. That's right. Exempt non-profit organizations are generally exempt from Do Not Call Registry. Calls which are not commercials do not include unsolicited advertisements. And so here are your best practices for TCPA compliance. And as you can see, a disclaimer on the bottom: this does not constitute legal advice. These are merely best practices. And if you are if you have a marketing company, a front-end company, a debt settlement company that is using an automated dialing system, you need to make sure before making those calls using ATDS that you obtain consent from consumers, and it has to be written consent. You provide disclosure. You allow someone to opt out. You allow those people to opt out of being contacted via telephone or text messages. You could only contact them during approved times. You avoid consumers that do not call registry. You abide by maximum number of characters, and you see in the last prong how many characters you could have. Basically, you can more than 160 characters, including spaces and punctuation. That's correct. So these are your best practices. You have 5 prongs here that you should be mindful of. Now, let's talk about some of the big cases. We're not going to discuss the Bar versus American Association of Political Consultants. Actually, that's the caption and appeal. For those of you attorneys, you obviously know if the case was appealed and accepted an appeal and the de novo standard review, the caption will actually change, because here the American Association of Political Consultants was actually the plaintiff, and they sued the Attorney General, Bar, and they sued the FCC alleging that the third prong of emergency purpose uses was violating the First Amendment. And the Supreme Court, it did go, can you imagine? We actually have a few cases, TCPA cases, that went to the Supreme Court. We'll discuss the second one in a minute. The Supreme Court actually held that the government debt exception violated the First Amendment as amended this provision of the TCPA. All right. Here's an interesting case. This is a federal case, and this is from July 2019. And this particular discusses the vicarious liability of businesses in TCPA violations. You see, one of the interesting legal issues that we often deal with is, it's not so much who actually gets sued because they violated the law. It's who else gets sued. What other party could be part of the lawsuit because they have some type of liability, and usually it's called vicarious liability. And here, in this particular case, a plaintiff alleged that North Star and Yodel violated TCPA when Yodel allegedly placed telemarketing calls to consumers to market North Star residential security and home automated system, right? So it was actually Yodel that was making the calls on behalf of North Star. The recorded calls at issue allegedly stated, with no apparent factual basis, that home security systems in your neighborhood have experienced issues with false alarms, creating a big concern, with crime rates and mass shootings on the rise in the U.S. and national security with our borders. And the court characterized the calls as plainly deceptive, right? Because obviously these were pre-recorded calls, and they were, obviously not specifically geared towards that specific neighborhood. And so the court actually found them to be deceptive. And the court found that North Star was vicariously liable for the actions of Yodel, right? Even though North Star was the customer of Yodel, it was vicariously liable, reasoning that North Star controlled the manner in which Yodel made the calls. And specifically, one, North Star was involved in determining the content of the pre-recorded messages Yodel used. Two, North Star was involved in determining which telephone numbers Yodels would call. Three, North Star changes Yodel's calling procedures. It regularly changed it, including content of calls. And four, North Star accepted and followed up on Yodel's lead. So as you could see, North Star, being the customer, had significant control of what Yodel was doing, and as such, the court found it to be vicariously liable. Here's a pretty interesting case, and this is a case from last year, Facebook versus DeGuid. I think I'm pronouncing it correctly, but of course, as you know, because it's an appeal, and I mentioned a few minutes ago, the true plaintiff here was actually Noah DeGuid, who sued Facebook because Facebook sent in text login notification in violation of the TCPA by using equipment that he said drew telephone numbers from a stored list. Facebook responded they sent the login information as a standard security measure and denied any TCPA violation as the list comprised of telephone numbers provided by its customers rather than numbers generated randomly, and thus an auto dialer as prohibited by TCPA was not used. And of course, this went to the Supreme Court, right? This was actually a pretty big deal when this case came out. The Supreme Court ruled that a necessary feature of an auto dialer under TCPA is the capacity to use a random or sequential number generator, to either, right, store or produce, emphasis that, of course, on either, store or produce numbers to be called, right? As you could see, we're focusing on a few keywords, right? We're looking at the capacity to use random or sequential number generator to either store or produce all numbers. Since Facebook used neither stored numbers nor produced numbers using random or sequential number generator, the text notification was not found to be in violation of TCPA, was not found to be a violation. The court ruled that an automated telephone dialing system, ATDS, under the TCPA is limited to devices that have the capacity to use a random or sequential number generator, random or sequential. And again, we're going to distinguish these keywords from the Florida TCPA statute that we will discuss in a few minutes. And so that concluded the federal TCPA, and we covered that in 22 minutes, which is impressive because I don't think it's easy to cover, to digest what really should be at least 2 to 3 hours of information to 25 minutes. What I've given you on the federal level is the very high level overview of the federal TCPA law, the TCPA statutory framework, the case law, and the regulatory actions that arise from multiple federal and also state regulators is quite complex, very complex. And, again, as some of you know, I always like to provide my thought on the subject, and my view is while TCPA is a very good consumer-friendly protection statute, it doesn't serve its purpose as well in 2021. And as we've been receiving more and more phone calls, spam calls by automated telephone dialing systems that are based outside of the US, it is very difficult to stop those calls. And so a lot of the burden to stop these calls now falls on the telephone service providers, right? On your phone provider to filter those calls. And even with those filters, you still get through to it. And then anyway, so let's move on to the Florida TCPA, I thought that we kind of the Florida TCPA. And here's why this is a very interesting statute. So this statute came into effect on July 1st of this year. And, there really wasn't as much attention. And I think there should have been more attention paid to the Florida TCPA legislative effort. It's unfortunate because the statute, in fact, is much broader. We'll talk about why it's broader than the federal TCPA, and what is the fallout of the Florida TCPA. And the question is whether the Florida TCPA statute will be challenged, even though we already said earlier during this webinar that the federal law specifically states that it doesn't preempt state law. So therefore, state law can preempt federal law in this, right? So if you have a more aggressive TCPA statute, you could have it. The question is whether it will survive, any challenges based on, potentially maybe whether some will, again, it's too early. The statute has been around for less than half a year, but I'm sure someone at some point in the state of Florida will question the legality of some of the provisions of the statute. And the next question is whether or not other states are going to follow the Florida mini TCPA statute. Typically, there are a few states that are sort of at the forefront of this more progressive, consumer-friendly protection laws, and one of them is, of course, being California. California is known for being at the forefront of promulgating and enforcing rules that are, arguably, maybe you could say, ahead of its times. I know that we could disagree whether or not some of these rules are a little bit too onerous, but many of us practitioners and also in the academia, we're a little bit surprised that this statute was specifically, enacted in the state of Florida. So let's dive into it. Okay, so the Florida TCPA amended the Florida Telemarketing Act by broadening the type of telecommunications equipment that fall under the purview and tightens the consent requirement. Okay. Florida's TCPA is a direct response to the U.S. Supreme Court's April 21 holding, right? This is very direct response. And we discussed this case, the Facebook case, in which the court unanimously held that the TCPA covers only random fired calls and text to cell phones from an ATDS. Of course, so this begs me to make a facetious comment. How often do you have the Supreme Court having a unanimously held decision, right? So the Supreme Court, right, both the Republican and Democratic elected justices have actually unanimously held that TCPA only really meant to cover the random fired calls. The Florida legislature contends that TCPA expressly permits state regulators to impose more restrictive interstate requirements and expressly disclaims a complete preemption of state laws governing the regulation of unsolicited sales calls and the improper use of pre-recorded messages claims. The Florida TCPA aims to crack down on telemarketing directed to Florida residents by prohibiting a person from making or knowingly allowing telephone sales call to be made if such call involves ATDS or the playing of a recorded message without the prior express written consent of the called party. And that's a very, very important part. So again, how do we get here? Let's say here, how do we get to the Florida TCPA law? It provides a more broader definition of ATDS. The statute applies the use of an automated system for the selection or dialing of a telephone number or numbers or the playing of a recorded message. This definition of the auto dialer is broader than the federal TCPA. It's broader because it also includes devices that use a random or sequential number generator, right? So if you, again, the Facebook case specifically said that only random. It narrowed down the federal TCPA. Here, it's random or sequential number generator. This has given rise to class action litigation in Florida, posing the issue of whether text messages that may be permissible to send without prior express written consent in many circumstances under TCPA require prior express written consent at the Florida new expensive auto dialer definition. As I mentioned earlier in my presentation, my firm has an office in Florida, headed by my partner Christina Indara, and since July of this year, more specifically since I would say August, our firm has handled a number of class action threats, written demands against companies, specifically in this industry, both front ends and back ends, who were sending out both random and sequential text messages and obviously also calls following the receipt of to individuals who had filled out a form online to be contacted, right? And so for those of you in the debt relief space, if you're sending something out by mail, that is not express consent. That is not express consent, okay? If someone's filling out your form, your lead form online, then you need to make sure that lead form correctly complies with Florida TCPA, specifically for Florida leads. If you don't, you will receive a demand letter. And we've dealt with a number of demand letters where they attach text messages and they said, you know, you're in violation of TCPA and your client should pony up some money. And then there's a question of whether or not, in fact, there's express written consent. Okay. Now, so we already said that the mini TCPA, the Florida's mini TCPA, I thought that's kind of always cute, the mini TCPA, even though it's actually a bigger TCPA, broadly defines to include an automated telephone dialing system for the selection of dialing telephone numbers playing a recorded message. Now, similarly to the federal TCPA, the Florida mini TCPA allows aggrieved parties to bring private cause of actions for violating. A prevailing plaintiff may recover actual damages. And obviously, look, I think we could all say that it's very difficult to say what your actual damages are, or $500, whichever is greater, plus attorney's fees and costs. The statute further authorizes treble damages for willful knowing violations. Right? So $500, right? So you obviously you obviously think, oh, $500, but if you have sent out 10,000 messages, you potentially will multiply that by 500. That's your worst case scenario, plus possibly attorney's fees, and that could be a very significant 7-digit number. So you have to be mindful of how many text messages or phone numbers. So while the $500 itself may not be a very big number, if you multiply it by thousands or millions, and I believe since now actually I'm a resident of the state of Florida, we have over 20 million, I believe, residents. That's a big, big number. Now, Florida's mini TCPA eliminates safe harbor provisions that we discussed a few minutes ago, that these harbors had allowed previously in Florida automated calls where the calls are made text sent in response to calls initiated by the call party. If the telephone numbers have been screened to include persons in Florida, no sales solicitation calls, or the calls to consumers, the call concerns goods or services previously ordered or purchased. So the safe harbor for previously purchased or previously serviced consumers has been eliminated. So again, begs the question: is this really a mini TCPA, or is it really a much more stringent TCPA? And I personally think it's obviously more stringent, and you have to pay very, very close attention to it. Now, so what are the key elements of TCPA? Let's kind of summarize this. We have the automated we have a definition of the automated auto dialer is broader than the federal TCPA. The statute applies to the use of an automated system for the selection or dialing of telephone numbers or in the playing of a recording a message. And this definition of auto dialer is much broader than the federal TCPA definition, right? The caller cannot intentionally conceal its name and telephone number or use technology that displays a different caller ID. You cannot. And you probably know that there are multiple systems in place. I mean, how many times have you probably received a phone call claiming to be an IRS agent and or someone from law enforcement, and this is obviously a scam. Or my favorite one is at least 3 times a day, somehow, regardless of all my spam filters and additional costs that I pay to Verizon Wireless, I get at least 3 phone calls of someone trying to sell me a car warranty, an extended car warranty on my car, which is kind of funny. And while I was preparing this presentation, I keep thinking about all these calls that I'm getting on a regular basis, and obviously the call is intentionally concealed in name and phone number, because if you ever tried to call them back, you would never get through, because that number just wouldn't be an active number. So I always think that's a very interesting analysis, right? There are no calls between 8 a.m. and 8 p.m., very different than the 9 p.m. Federal level restriction. And this is also a very big one. More than 3 phone calls can be made during a 24-hour period, regardless of the phone number used to make the call, right? So if your business has 5 phone numbers, it doesn't mean that you could make 15 calls. No, it's still 3 calls per business, right? In a 24-hour period. And a number of exemptions apply to the requirements of the Florida's TCPA, including exemptions covering supervised financial institutions operating within supervised activity. Okay, so here's another one. Here's number 6, another element. The statute sets out, and this is really the key here. I think this, if you're still with me, I'm very proud of you. You've been with me now for 35 minutes. That's incredible. So the statute sets out specific requirements for obtaining prior express written consent. If there's anything that I want you to take away from this webinar, which I hope this is not the only thing that I take away from this webinar, but if this is one thing, it's the 6th prong right here. This is really, really important. Okay, so under the statute, prior express written consent means an agreement that one, and by the way, this is a 3-prong test, and you see there's an N up to 2, so it's a 3-prong test. So you have to bear the signature of the call party, clearly authorizes the delivery of a telephoning sales call using an ATDS for the selection of dialing numbers or playing a recorded message when the connection is completed to a number called, or the transmission of pre-recorded call to the call party, right? That's prong 2. And 3 includes the telephone number to which the call may be delivered. Okay? The written agreement must also contain the following 2 clear and conspicuous disclosures. And this is what you should do. You should, I mean, again, this is not for legal advice, but you should, this is from the statute. So there you go. So I hope you got your 37 minutes worth of my webinar presentation today. You should copy and paste that if you're contacting Florida consumers, because that has to be clearly, conspicuously disclosed to Florida residents. And I'm not going to read those 2 prongs, but it's right there. It's right there from the statute. You need to make sure that those disclosures are prominently, clearly and conspicuously noted to your Florida consumers. Number 7, the statute prohibits the use of technology that conceals the identity of a caller. We talked about it. The statute imposes new limits, time limits, so it's different. We talked about, there's no point to rehash that. And finally, the aggrieved parties have a private cause of action, and we talked about this. $500 in statutory, of $1,500 for willful violation. And also, this is interesting, right? Because when we receive letters from the plaintiff's bar or attorney's representative, aggrieved consumers, they somehow put in $1,500. And an initial phone call, I tell them, well, hold your horses. Where are you getting $1,500? And they said, no, these are statutory damages. And then I said, that's incorrect. It's actually maximum of $500. It's up to $500 and $1,500 for willful violation. And willful has to be proven to be willful. There has to be an intent to intentionally violate the statute. So the short answer is, forget about your $1,500. I'm not even saying 500 is a good number, but that is one of the biggest mistakes the plaintiff's bar makes when they contact us. Okay. Since July 2021 inception, one Florida law firm, I'm not in position to discuss this law firm, but anyway, there's actually more than one, but one is prosecuting TCPA claims that's filed at least a half a dozen class action complaints. Can you imagine this? In 5 months since the statute went into effect, half a dozen class actions by one law firm. In each case, the plaintiff alleges the defendant transmitted the telephone sales calls using a computer software system that automatically selected and dialed plaintiffs and class members' telephone numbers. Okay? The complaints involve businesses located in different states, in different areas of business, including a diamond tool supplier, for instance, a manufacturer and seller of indoor and outdoor elliptical bicycles based in Huntington Beach, a California mortgage lender based in San Diego, a Dallas, Texas-based owner-operator national restaurant chain, and a battery light club retailer located in Wisconsin. So as you can see, we have a pretty big variety of a geographically diverse group of defendants, and if you're part of the debt relief space, you need to be mindful. This doesn't just apply to debt relief; applies to everybody else. But clearly, you need to pay attention to both the federal and the Florida TCPA laws. And so while these cases are pending, their present value suggests that businesses engage in telemarketing communications with Florida residents, especially through the use of text messages and recorded messages. They need to ensure their practices take this Florida law into consideration to avoid becoming a litigation target. These are some of the cases that I'm not going to discuss these cases, but you can look them up. Feel free to email me. I could email you these cases and you can then go and try to see what the complaints are. We can discuss them. But in each case, the plaintiff seeks an injunction in statutory damages on behalf of himself or herself and the class members. In all these cases involve text messages, right? Which may be permissible to send without prior consent. In many circumstances under the federal TCPA, but may potentially, again, I'm not in a position to discuss the merits of this case, may potentially be in violation of Florida vague and expansive order dial definition. Again, I'm not in a position to discuss the merits of this case, but I can tell you, as we discussed during this educational webinar, that these cases, that the Florida TCPA is much more broader and vague. Well, I appreciate we've done this in 42 minutes. 42 minutes. I'm very, very grateful for your participation. Thank you for sticking around me for 42 minutes of listening about the federal and state TCPA laws. It's always a pleasure to have all of you who continuously follow our webinars, both live and recorded sessions. And hopefully most of you who can attend our last 2021 kind of year-end wrap-up, which will be with Nick Cosmas, the General Counsel of Clear One Advantage. Thank you, and it was a pleasure. I look forward to seeing you at future webinars.